Confederate tribes and bands of the Yakama Nation and Okanogan County have been arguing land rights in the Superior Court, and the Yakama Nation is now escalating their dispute to the Division III Court of Appeals. Here's what happened. The Yakama Nation agreed to dismiss a lawsuit against Okanogan County following an agreement the county would adopt a new county plan and zoning ordinance that would address the nation's rights and concerns. Based on this agreement, the county would adopt the new plan by December 18, 2018. The Superior Court signed an order of dismissal without prejudice. The county failed to adopt a new plan by this date, and as such, the nation moved to vacate the Superior Court's order of dismissal. The Superior Court denied the motion to vacate on the grounds it had no authority to vacate an order of dismissal without prejudice, and the nation had no cause of action against the county for breaching its promises or violating the court order. Now, the Yakama Nation appeals the Superior Court's decision. Let's get it started.
Confederated Tribes and Bands of the Yakama Nation versus Okanogan County. Participating or joining me on the panel today are Judges Robert Lawrenceberry and George Fearing. George Fearing is in the courtroom, which is why he is wearing a mask. I am in my chambers and Mr. Lawrenceberry is in Yakima. So let's see, we're starting with you, Mr. Sexton, and I think you've argued before us before, so you're familiar with our timer, aren't you?
Yes, Your Honor.
Okay. Well, let us know how much time you'd like to reserve, and I'll ask anyone who's not speaking to put themselves on mute, and then you can proceed.
Thank you, Your Honor. May it please the court. Joe Sexton on behalf of the Confederated Tribes and Bands of the Yakama Nation. I request to reserve 5 minutes of my time for rebuttal. This is a case about an ongoing violation of a court order. That court order incorporates a settlement agreement between the parties and dismissed the Yakama Nation's lawsuit, giving rise to that settlement without prejudice. The court below refused to vacate that order of dismissal despite the county's admitted breach of the settlement terms the county negotiated to induce the dismissal. That refusal, for any and all reasons cited, was an abuse of discretion, and it sets a precedent contrary to public policy that disincentivizes settlement agreements.
Mr.
By way of,
Sexton,
yes,
Mr.
Your Honor.
Sexton, under what authority did you move at the trial court level to vacate the order of dismissal?
Under CR 60, Your Honor.
Which subsection?
It would be subsection 11, I believe, Your Honor. This was the
catch-all?
Yes, Your Honor. Effectively, it's a manifest injustice to not allow the Yakama Nation to proceed with its lawsuit on its merits in light of the county. You know, whatever attempts it made to comply with the order, it was in violation of a court order. And so the court order should have been vacated.
My understanding is that Judge Rawson didn't prohibit you from proceeding with the matter. He just required that you file a new lawsuit. He said the effect of dismissal was as if the original lawsuit never was filed. So how does him just allowing for a different procedure, how is that a manifest injustice?
Well, it's a very good question, Your Honor. It actually hits on one of the untenable reasons underlying Judge Rawson's decision to deny the Yakama Nation's motion to vacate. Because Judge Rawson is right in a sense, the Yakama Nation theoretically could go file a new lawsuit on a breach of contract or breach of settlement agreement claims. But if it attempted to loop the 2016 claims it made in litigation when the county made a final legislative act codifying its zoning code in 2016, the first thing the Yakama Nation would face would be a motion to dismiss based on statute of limitations grounds.
Well,
so
why can't you though request specific performance of the agreement? That wouldn't be barred by a statute of limitations, would it?
Well, Your Honor, no. I mean, it would if the agreement ties back to the Yakama Nation's 2016 claims, which are based on various
agreement. It's got a 6-year statute.
Yes, Your Honor, and that's fine, but we still would the manifest injustice here is effectively Judge Rawson's decision makes the Yakama Nation's 2016 litigation act like effectively renders it null and void, and it's not null and void. It was settled, and certain provisions the county agreed to undertake within a certain amount of time. It failed to undertake those, and the agreement was that if the county failed to undertake those, the Yakama Nation could go back to that 2016 litigation, could go back to the claims that it made that remain viable and justiciable to this day.
Let me ask you about another possible avenue, and that is we are aware from FutureWise's motion to participate as amicus that your case was consolidated with another case that was brought by other parties. Could you move to intervene in their lawsuit? Because their lawsuit was just stayed, and as I understand it, is ongoing.
Theoretically, Your Honor, we could, but I don't know if the county would agree to that and would fight that. And frankly, the Yakama Nation shouldn't have to move to intervene in a separate lawsuit. When, Your Honor, the issue there's two basic questions before this court today. One is whether the court below had jurisdiction to vacate the order of dismissal, to enforce and vindicate its authority under its order. And that issue was foreclosed by the Supreme Court in Condon versus Condon. And the Yakama Nation did exactly as the Washington Supreme Court prescribed in Condon for a party who was aggrieved post-dismissal by a violation of a court order and a settlement agreement. And the Supreme Court there, quoting from the US Supreme Court, says when the party's obligation to comply with the terms of the settlement agreement had been made part of the order of dismissal, then a breach of the agreement would be a violation of the order, and ancillary and jurisdiction to enforce the agreement would therefore exist. That's at page 159 of the Condon decision. So, Your Honor, the Yakama Nation shouldn't have to file a new lawsuit and then deal with jurisdictional challenges on the merits of its 2016 claims, which relate to a zoning code that remains in effect, that is affecting the rights of citizens and stakeholders in the county and in the state alike as we speak. It shouldn't have to seek to.
I think the problem you have is the problem that Judge Rawson identified, which is given the particular language of your order, the settlement agreement wasn't incorporated in the same way that it was in the Condon case.
Respectfully, Your Honor, in the Condon case, I believe the procedure was the parties actually did not move to vacate. They just brought a motion to enforce the settlement order. And the Supreme Court in Condon says the proper procedure, and this follows the Washington Practice Guide, the proper procedure is to go and file a motion to vacate. And then you vacate the order of dismissal, and then you decide what you're going to do from there. And that's really what should happen here. That's the easiest. That's the most. That's in keeping with judicial economy, and it minimizes the prejudice to all parties. The county at that point could file a motion for summary judgment if, as it claims here, the Yakama Nation's claims in the 2016 litigation are no longer justiciable. And if it wins, it wins. But the Yakama Nation has a right, now that the county has walked away from the settlement agreement, its obligations to, one, repeal and replace both its comprehensive plan and its zoning code in their entirety by December 31st, 2018. We're 2 years from that date, and the county has still failed to do that. The county filed a declaration in the motion practice on this in 2019 from Mr. Perry Houston. This is at page 103 of the clerk's records. And Mr. Houston says the comprehensive plan is going to be repealed and replaced by the end of 2019 or at early 2020. So we're a year past that now. The fact is the Yakama Nation has a right to proceed with its 2016 lawsuit because the county has walked away from the unambiguous commitments it itself negotiated. The Yakama Nation didn't pick 2018, the end of 2018, for the deadline for the county to repeal and replace its comprehensive plan and its zoning code. The county chose the state. Now, if I'm a litigant or I'm a lawyer for a party and I'm running up against the court deadline, the first thing I'm going to go do is go seek relief from the court and go to the other party and see how we can work together to change the court order so that I don't run afoul of a court order. The county didn't do that. The Yakama Nation mailed the county a letter in the spring of 2018 or 2019 in April, indicating that, hey, you missed this deadline. Let's work together. Let's do something, or else the Yakama Nation is going to bring a motion to vacate, as the Supreme Court prescribes in Condon.
Mr. Sexton, did the nation's causes of action merge into the settlement agreement?
I'm sorry, I don't understand your question, Your Honor. The settlement agreement certainly was part of the cause of action. If that's answers your question.
Did the Yakama Nation agree to forego its causes of action by reason of the settlement agreement? And I read from paragraph 1 of the stipulation, the dismissal is made without prejudice to any future claims or defenses. This includes without limitation any future claims based on the county's actions or failure to act. Does that show an intent that the causes of action are no longer viable and that the nation is rights are limited to what's in the agreement?
Respectfully, not at all, Your Honor. That the intent of that language was specifically raised because the county refused to undertake certain measures as part of the settlement agreement that the Yakama Nation requested. So it said, hey, look, we're gonna open the books back up and we're gonna go back and revise this comprehensive plan and this zoning code, but we're not gonna commit to anything in particular, and we're not gonna have a moratorium in place that's gonna prevent us from making land use decisions in the interim in these 2 years that we're gonna have to work on our comprehensive plan and zoning code. So the Yakama Nation wanted to make sure that it had a right to preserve future claims, specific claims on these land use decisions being made on the county zoning code that runs afoul of Washington state law. Your Honors, the court abused
future claims that arise after the settlement agreement, not claims that were pled in the causes of action, correct?
the claims that were pled in the causes of action were preserved if two parties settle a case.
They're preserved with regard to conduct after the agreement, correct?
That's not how I read that language, Your Honor. That doesn't limit the Yakama Nation's claims, and nowhere in the order of dismissal did the Yakama Nation agree to waive its claims that it raised in the 2016 lawsuit. When parties
it still can raise the Growth Management Act, the Land Use Protection Act, SEPA, but only with regard to conduct after the agreement. Would you agree with that?
No, Your Honor, we would not agree with that. That's not what the order of dismissal says, with respect. And I see that I have run through a little bit of my time that I hope to reserve for rebuttal. So unless there are any further questions, I request to reserve the remainder of my time for rebuttal. Thank you, Your Honor.
Could the Yakama Nation, Mr. Sexton, enforce the terms of the order within the same cause number without vacating the order of dismissal?
That's an interesting question, Your Honor, but that's not how the Yakama Nation followed the prescription that the Condon Court set out on what parties should do. When a party walks away from a settlement agreement or violates the specific terms of a settlement agreement, that's exactly what the county has done. You're going to hear a lot about, hey, we're in the process of complying, but again, the county negotiated these terms. You're not going to hear from the county that they're in compliance with these terms. So theoretically,
did the Condon Court limit the remedy to enforcement of the agreement as opposed to allowing the one party to assert new rights?
I don't believe that it did, Your Honor, but I'll look at that and respond if Your Honor wishes to have an answer on that question.
And I apologize for going into your rebuttal.
Thank you, Your Honor. Appreciate it.
All right, Mr. Little, please unmute, and I'm going to start with a question for you, the same question I asked Mr. Sexton. And I want to be clear, I haven't looked into the law of intervention, but if the nation wanted to intervene in the FutureWise lawsuit, how could the county possibly be prejudiced by that? Because they were, of course, involved in similar litigation with the nation previously, and they were aware from the settlement agreement that the nation had an ongoing concern in the same issues. So do you see any prejudice to the county if the nation wished to intervene in the FutureWise lawsuit?
Thank you, Your Honor. I am not aware of the current status of that other lawsuit, but and I confess I haven't looked into that possibility that you raise specifically. However, I think the concern about justiciability would apply equally to both the current Yakama Nation lawsuit and the other lawsuit involving FutureWise and the Metho Valley Community Council, and whether the lack of a justiciable controversy in that case would preclude intervention is a question I'm afraid I haven't looked into, but I think in both cases there's a lack of an effective remedy, because all the court can really do in an instance like this is to order the parties to, or rather the county, to continue doing what it's doing and continue to revise its comprehensive plan and zone code. And at this stage, the old zone code is being revised, and so a challenge under the statute, under the various statutes, the Planning Enabling Act, the Growth Management Act, and SEPA would be moot as to that, the old 2016 zone code, and not ripe as to the zone code that's currently being developed. So I think regardless of which case we're speaking of, there is an issue of a lack of an appropriate and final remedy, and that judicial intervention in either case would be inappropriate.
Mr. Little, the order of dismissal reads, no later than December 31, 2018, the county shall take final legislative action to repeal the current plan and zoning ordinance and adopt a new comprehensive plan and new zoning ordinance. Has the county violated that order?
The county has not done either of those things to date. That is true.
So has the county violated the order?
Yes, the county is not in compliance with that deadline. The county.
So why isn't there a justifiable issue if the county has violated an order and a settlement agreement?
The issue, I think, is whether there is anything to be done by a court at this point. I don't think the question of the county's diligence in attempting to meet the deadline was raised or is before this court. Only a narrow issue. Is
there anything in the order in the settlement agreement that excuses the county from complying with the order and the agreement as long as it is duly diligent?
I'm not aware of specific language that meets the criteria you speak of, Your Honor.
And is the Skamania County case and other cases that you cite distinguishable because in those cases, the municipal authority never came to an agreement as to a deadline of adopting certain plans and codes?
I think the general principle applies. I think the principle of justiciability applies to any case, regardless of whether a settlement agreement is involved or not.
In the cases that you cite, did the municipal authority come to any agreement to adopt a plan or a code by a specific date?
I'm not aware that they did.
Is it the county's position that the settlement agreement and the order of dismissal is not binding on it?
May I just return to your previous question? I do believe, and I'll get to this one, the Summit County case cited in the context of the growth management. I believe there was a date certain in that case. It was a 2019 unpublished case from Division 2, and the Pierce County in that case, it failed to meet a deadline to revise its comprehensive plan. So I regret to say I don't recall whether it was by agreement or some other cause, but there was a missed deadline in that case. So I would draw your attention to that, that case. And I apologize, I've forgotten your.
Is it the county's position that the settlement agreement is unenforceable and the terms of the order of dismissal are unenforceable?
I think what the Yakama Nation is seeking to do in this case, to vacate the order of dismissal is untenable here because it is a condition precedent to vacating any order of dismissal that there be a viable, valid, and meritorious underlying cause of action. And here we simply don't have those things because of the lack of justiciability. The only thing the court can do is to order the county to continue what it is doing now, and that is not an appropriate judicial intervention. I think the Save Our Scenic Area case is on point in that respect, as well as the cases cited in the context of SEPA. Judicial review of SEPA, interlocutory review before the final regulations issue is simply precluded.
What I'm trying to get at is I might conclude that the Yakama Nation rights are limited to enforcing this agreement. But if it's the county's position that the agreement is not enforceable, never was enforceable, I might change my mind and say the Yakama Nation is not limited to the rights in the agreement in the order because the county says it's not valid. Is it the county's position that the order is not enforceable?
The order is not enforceable. It can't be vacated, and the underlying litigation can't be restarted at this stage.
Are you saying that if the Yakama Nation brought a separate lawsuit to enforce the settlement agreement and the order of dismissal, that it would be the county's position that neither are enforceable?
It would be the county's position that that separate lawsuit that you're suggesting could be filed would again not present a justiciable controversy for a court to intervene in an ongoing legislative process.
Because the order has not been violated, or because the order is unenforceable?
Because there's no appropriate remedy in this case. A court simply can't intervene in an ongoing process of redoing the zoning comprehensive plan and zoning code.
Well,
that's not the court's role to intervene while that is ongoing.
Let's assume the court concludes that Okanogan County has violated the order of dismissal by failing to adopt the comprehensive plan and the zoning code by December 31, 2018. Could the court impose, as a matter of contempt, a daily fine against the county until it complies with the court order, just as the Supreme Court in the McCleary case imposed a daily fine on the state of Washington until the legislature complied with its order to provide full funding for Washington state education?
Your Honor, I believe the court in that case would need to find that there was an intentional violation of the stipulation and order, and I don't think that the court could find that in this case. A finding of intent is required in order to hold a party in contempt.
Well, I could see your point if it was not within the power of the county to comply with its agreement. If it was helpless and had no possible way of complying. But if it was within the power of the county to comply, why shouldn't the court be able to find contempt and sanction it? I
Well, I
mean,
think,
the county is way past the deadline now.
right, I do think it's worth recalling that what's before the court is the issues that were presented to Judge Rawson at the time of his decision. And I think we put in the record extensive and unrebutted testimony from the planning director at the time, who testified to numerous meetings and planning sessions with the planning commission, with the various stakeholders. The fact is that this is not a simple process in complying with SEPA when you have limited staffing and are attempting to comply with the stipulation to have input from all the stakeholders. That's just.
But the county
I
knew
think
that
Judge.
going in. The county knew that going in, that there might be a timeline, but they agreed to the timeline. They knew it'd be difficult to meet.
I'm not sure the thinking of the county on that is in the record at this stage, respectfully, but I agree in retrospect, clearly it wasn't something that the county could meet. And I think Judge Sidaway also makes a good point with respect to the impossibility defense with respect to any potential finding of contempt. I think the county, it's unrebutted, and it's not before this court, that the county was diligent. I think that the trial court finding and words were that both parties were serious in their attempts to collaborate and move the process forward. And that's
Did Mr. Houston in his affidavit say that it was impossible to meet the December 31, 2018 deadline?
I'm not aware that he said it was impossible. I think he said that the county had worked diligently throughout the time available, and that no one was in bad faith or attempting to slow walk or the county was exercising diligent and good faith efforts to move the process forward. I believe that was the substance of his testimony.
The county contends that Yakama Nation did not assign error or raise an issue with regard to the specific ruling made by Judge Rawson. The Yakama Nation's brief assigns error to the Superior Court's order denying the motion to vacate. And in the issues, Yakama Nation states that Okanogan County violated the terms of the dismissal order. Does this assignment of error and the issue stated in the brief preserve the argument that the trial court erred by ruling that the Yakama Nation had no viable cause of action?
I think I'm not sure I understand the question, but I think it was a narrow issue that was raised. It was simply whether the trial court had jurisdiction to consider the request, and in fact, the basis for the trial court's ruling, as stated in our briefing, was one of justiciability and the lack of an appropriate remedy.
Isn't judiciability and lack of jurisdiction sometimes used similarly?
I don't think that the Yakama Nation's briefing addressed that issue to any significant degree. I don't think it was properly raised.
If there are no further questions, Mr. Little, you've used up your time. Do you have any further questions, Judge Fearing or Judge Lawrence Fearing?
I do not. Thank you.
Question.
Thank you, Mr. Little.
I have one question. The original lawsuit, it was dismissed without prejudice. Doesn't that mean that the causes of action that were originally asserted, that they could be asserted again?
I think in the proper context, they could be, but not where the county is involved in an ongoing process of rewriting the comprehensive plan and zoning codes.
Okay, thank you very much.
Thank you.
Mr. Sexton? You're muted.
I'm sorry, I'm just getting used to
Mi-
this Zoom
Mr.
hearing.
Mr. Sexton, would you please address the county's argument that the nation did not assign error to the specific ruling of the trial court, please?
Yes, Your Honor. There's a couple points on that in particular. One, the appeal the Yakama Nation brings alleges abuse of discretion. Any untenable reason or untenable ground upon which Judge Rawson relied to deny the Yakama Nation's motion to vacate is squarely before this court on appeal, including issues of justiciability. I mean, Judge Rawson had relied, if you look at the record of proceedings, there was no ruling in terms of findings of fact and conclusions of law. And in fact, the Yakama Nation requested that and the court denied it. So the rulings are effectively one sentence. The Yakama Nation's motion is denied. And the Yakama Nation wrapped up, to your point, Judge Fearing, wrapped up in the jurisdictional question is justiciability, whether there's a valid case that's been right. If there's not, then I believe a court wouldn't have jurisdiction to hear the case. In this case, the Okanogan County's 2016 zoning code remains in effect. Land use decisions are being made on that code, interim amendments or not. And so the Yakama Nation's lawsuit remains justiciable, and that issue is squarely before this court on this appeal. A couple additional points I wanted to raise to clarify some of the cases the county relies on. These cases are either distinguishable on facts or law, or they actually, if you dig into them, they support the Yakama Nation's position. The county cites to Summit Waller Community Association versus Pierce County, and this was a decision the county's attorney raised on the issue of a deadline. In that case, Pierce County was required to revisit its comprehensive plan by statute by June 30th, 2015. And then it did revisit and passed amendments to that statute on February 1st, 2016. And then there was an appeal. So the question on appeal that dealt with a number of irrelevant issues for purposes of this appeal. But ultimately, the court said, what remedy can we give you because the county violated the deadline, but ended up amending its comprehensive plan anyways? Here, we have a court-ordered deadline agreed to by the county, and the county hasn't repealed and replaced its comprehensive plan or its zoning code as it promised to do. The same thing with the Skamania County case. The Skamania County case, if you read that, the Supreme Court says, look, the parties waited until the county took final legislative action and then they sued. And in this case, that's exactly what the Yakama Nation did. They waited until the county took final legislative action on its 2016 zoning code, and then it sued. And in Skamania County, you had the addition, there's a moratorium in place. Here, there is no moratorium. So again, you have these land use decisions that are ongoing. And Your Honors, I tend to avoid slippery slope arguments because they're usually interlaced with hyperbole, but in this case, there's a real danger in the precedent the trial court is setting here. Public policy in Washington clearly favors settling cases, and binding Washington law under Condon clearly favors courts enforcing orders memorializing those agreements. If a county court allows any party, much less a government entity, to not only flout settlement obligations, but court orders, we will have made bad common law disincentivizing these agreements and undermining public confidence in the power of the courts to make sure those settlement agreements are validly executed. For the foregoing reasons, we ask this court to reverse and remand the trial court's decision as an abuse of discretion and require the order of dismissal in this case be vacated for further proceedings. If there are no more questions, that is the end of the Yakama Nation's argument. Thank you, Your Honor.
Thank you both, counsel. The matter is submitted and will be in recess.
Thank you.
Because the order of dismissal included multiple obligations on the county, many of which were violated, the court reverses the Superior Court's decision. The court also acknowledged this was one of the endless broken promises by American government authorities towards Native Americans. There you have it, folks. Let me know what you think in the comments below.